All right, got it. We're live streaming now.
Wonderful. Without a hitch, we started this time. All right. Good morning, everyone. I'm Delegate Lily Chi, and this is the Business Regulation Subcommittee second meeting work session. I want to welcome all the members and the guests. Today is Wednesday, March the 8th, International Women's Day. I want to pay tribute to that important day. We have 5 bills on our list. We may not be able to vote on all of them because some bills warrant discussions, and we are also still waiting on some amendments that were supposed to be sent to us, but we have not received. So you can feel free to raise some questions. But let me start with the last one on our list, because Tiffany needs to leave after this bill discussion. So we're going to start with HB 907, which is public safety out of service elevators repair contracts. So
yes,
please.
This bill authorizes a landlord or landlord's agent to enter into a contract with a licensed elevator contractor other than the one with whom the landlord currently has a contract without penalty if the new contractor is able to repair the elevator before the current contractor. This authorization only applies if the elevator is out of service and located in a multifamily dwelling unit in which a disabled tenant or a disabled tenant who is at least 60 years old resides. There was no opposition to the bill, and there is one amendment to the bill. And the amendment extends this new authorization to all types of property owners, multifamily property ownership, and doesn't limit it to just landlord and tenant situations.
Okay, thank you, Tiffany. Delegate Pippi.
Sure. So was there any discussion with the bill to give a window to where the existing contract holder could remedy the situation before moving on to another contract?
Well, it says in the bill that the current elevator contractor can't do it. So it has to be in a time where they can't do it. So it's not just, oh, I don't like you anymore.
Say that.
1 second.
It simply gives
So it is in, there's no subsection, but in 2 on page 2, in line 3. So, or the landlord's agent intends to enter into a contract, is able to repair the elevator before the elevator contract with whom the landlord has a contract. Does that answer your question?
No, isn't it saying that the new contractor is able to repair it?
Yeah, they're saying that you can enter into a new contract with a new elevator provider if the new elevator provider is able to repair the contract before the old elevator provider is able to, repair the elevator.
that answer your question, Delegate Pippi?
Yeah, I mean, so is it a time? Okay, so it's a timing thing. So like example. So split hairs on it, but if I have an elevator that's out, it's Monday. I call our existing contractor who's like, I can come out at 9 a.m. on Tuesday. But there's another company that's like, well, I can come out today at noon. This law would permit the new company to come today at noon versus the existing contractor to come the next day. Is that fair to say?
Technically, no, you are correct, but there is something, if you would like to put something in there about timing, reasonable timing or something, that's possible too, but that's why we're discussing it.
Yeah, I mean, I don't want, the old lady to take the steps for the next month, which is the intent of the bill. But at the same token, I mean, it's like, you're breaking contracts, which thing. I don't know. Does anyone else have any thoughts about it? I'll yield.
Let me hear from Delegate Adams first.
So the way I understand the bill is if you're a multifamily property owner, you enter into service contracts. So it might cost, I don't know, $3,000 a year to enter to an annual contract with the elevator service company with the idea that if there's a problem, I call them, they come fix it, and that service contract would pay for some, but maybe not all of the repairs. And I'm assuming what happens is I get a call from somebody that lives on floor 3, who's 60 years old and simply can't use the steps. And so these service contracts, of which I am party to, not elevator contracts, but HVAC, for example, you're compelled to use them. That's the business relationship on a contract, that you can't use another provider. So what this bill is doing is, I think it's allowing a landlord, a property owner to break a contract for certain circumstances. So like it calls out in the bill that the person has to be over a certain age or disabled.
60 and disabled.
And so
Facility, yeah.
you would think they could do this in contract, but here the bill is, probably because there was some example in the delegates district where this happened, and the property owner said, I got tangled up in my contract. And Jesse, you're, as a lawyer, I think you're right. Contracts are binding, and I think we would want to pay caution to whether or not we, as a legislature, want to do that. But I do understand why the bill's here and can relate to, like if you have an HVAC contract and it's 98 degrees outside and the air conditioning goes out and it takes 4 or 5 days for somebody to come in, if I could get another provider to show up that afternoon, I bet I would make my tenant very happy. So those are my thoughts.
Thank you. I see Delegate Queen's hand is up, but let me just first say, this is very, very specifically tailored to the kind of multifamily dwelling units in which a disabled tenant who is at least 60 years of age or older. So it's very narrowly tailored in that kind of circumstance where mobility is critical for some people.
Madam Chair.
Yeah.
It's an or, so it's disabled tenant or.
Oh, or, okay. Thanks
who's
for the
60.
correction.
Yeah, so you could have a very youthful 60-year-old able-bodied tenant as well that I would.
You for the correction, Delegate Queen.
Thank you,
Yeah,
Madam
thank
Chair. Yeah, I got it. Sorry about that. So I kind of wanted to ask the question, and I think Delegate Adams was getting to it. So are there clauses in other contracts that for an emergency, you can do certain things? Because I remember once when I had an elderly person, family member living with me, and I had some issues with BG&E and service. It was like if you called and told them, you had an elderly person that, is on some type of device that needs the electricity, they do make special efforts to get out there. If they can't, aren't you able to, for emergencies, kind of break the contract to go get somebody to fix something? I mean, you mentioned the 90 degrees day and you need HVAC. I mean, you can't have people who need that service to wait 2 or 3 days. I mean, isn't that typical to have some emergency clause?
Well,
Yeah, so,
from the oral, sorry, were you speak? I'm sorry. Go ahead, Delegate.
Go ahead, Council. No, go ahead, Council.
Okay, well, from oral and written testimony, particularly, I think with these like elevator contracts and these HVAC contracts are like exclusive agent deals or whatever. I don't think that there are exemptions for emergencies from what we're reading in the testimony. I'm sure, in other situations there probably are, but I don't know if it's common. And I do think it is an issue from what the testimony brought out.
Sure.
I mean, if anybody else has any information.
Service contracts are for keeping costs down and having a fixed expense for standard maintenance. That's the benefit. The reason why I would be supportive of a bill like this is that under circumstances, a contract could actually harm a landlord's ability to cure a problem. So anyway, I understand why the bill's here, and I think it is narrowly tailored to probably a situation that rarely occurs. Surely landlords are going to want to solve it. It's just a matter of if their current provider can't do it, they should be able to pick up the phone and just figure it out for that very specific circumstance.
And I, to Delegate Pippi's point, I understand technically. That's the argument or thinking, but I think in real life, most likely a landlord would want to keep the current contract if it's just a matter of a couple of days, probably, right, of inconvenience, rather than entering into a brand new contract for repair. This is probably the circumstance where they are frustrated, where they have to call in extra help just to move somebody who was on some kind of dialysis schedule, so it's an enabling thing. But anyone else has questions or concerns? Are we ready to vote, or do you want to offer an amendment?
Well, I mean, would you be open to an amendment?
Yeah.
I mean, the only thought I would have, I mean, just if there was something related to, limited mobility. I know we have disabled tenant or someone who's at least 60 years old, but I mean, 60 is pretty young. There's a lot of our colleagues that are 60, just saying. And then the other part, if we could add a reasonable standard somewhere on page 2.
You have earned a lot of friends today, my friend.
I mean, because I think, like you said, if it's a matter of hours, like, hey, I can be there at 4 p.m. to fix this. And they're like, no, I can be there at 3. We're breaking this contract. I mean.
Yeah, no, I understand. We get your point. Do you want to put in an amendment?
I mean, I don't have one written up, but
yeah.
Add the
Okay,
word
we can hold this
on page
for
2.
you. Okay.
We can hold it.
We can hold this for you to offer an amendment tomorrow. Is that okay? Can you offer it tomorrow? Today, later today or something?
Yeah, I'll get you some.
Okay, great. Thank you very much. All right. Let's get going. Thank you, Council. Thank you, Tiffany. Okay, all right. Now let's go to the top of the list, HB 132, which happens to be my bill. It's heating, ventilation, air conditioning, and refrigeration services, journeyman license qualifications.
Good morning, everyone. I apologize for my voice. This bill increases the number of years from 3 to 4. An applicant must be licensed as an apprentice before applying for a journeyman license. Additionally, the bill increases the hours of training required from 1,875 to 6,000 for a journeyman license applicant. As of now, I've received no amendments for the bill.
Move favorable.
Okay. I just had one question. So Delegate Aaron did not.
We have a second. Hold on one second.
Second.
Thank you. All right. Delegate Queen.
I just wanted to ask the question. So Delegate Aaron's didn't put in an amendment because I think we were holding it for his amendment.
As of now, the committee doesn't have, I checked yesterday, the committee hasn't received anything.
Okay, because I did share some of his concerns about the extra time for some people, but if he didn't put anything in, I guess we'll.
Yeah, so the proposed hours and years were like the midpoint. It's not even where the apprentices will have to go through according to the Department of Labor standards. And on the Senate side, they did pass it unanimously without amendment.
Okay.
Crosby, sorry.
I'll second.
Thank you, Madam Chair. Just a quick question, and this is more of a process question. Even if we passed it out of here, Delegate Aaron could still present his amendment in full committee, correct?
He could.
Yeah, okay.
All right, so we have a favorable motion and it's being seconded. Council, would you like to take the vote?
Sure.
Second.
Well, excuse me, I have it initially seconded by Delegate Boafo.
Oh,
Okay.
that's right. Yeah. It's seconded a second time. Okay.
So I'll start with Delegate Adams,
Yes.
Delegate Boafo,
Aye.
Delegate Howard,
Yes.
Delegate Crosby,
Aye.
Delegate Pippi,
No.
Delegate Queen,
Yes.
Delegate Valderrama,
Aye.
Delegate Weigel,
No.
and Madam Chair.
Yes. Okay. The favorable motion passes.
Yes, ma'am.
Thank you. All right. The next one
Madam
is,
Chair, quick question.
Yeah.
Just based on what Vice Chair Crosby said, you can go ahead and vote on the elevator one too, because to his point, if there's an amendment, we can always do that in committee. That way we're not holding you up. You're good with that.
okay, we can
Hold
go
that
back.
bill,
And,
so.
yeah, well, we were waiting for your amendment if you on the order, or if you want to offer to the whole committee, yes, we can vote on HB 907. But Tiffany is not, the council is not here. Erica, what do you think? Should we wait for the council to come? Oh,
You
you're here.
magically appeared.
She magically appeared. Okay. All right. So Tiffany, you heard our conversation, I hope?
No, I didn't. I'm sorry, I ran to the
Okay.
restroom.
Yeah, so Delegate Pippi said we can go ahead and vote, then vote out the committee, and then he can offer the amendment to make it even more specific, to clarify the clarifying language.
I think that's
HB
fine.
907. Okay. So does anyone want to offer a motion?
I make a motion.
Favorable? Okay. All right. Anyone wants to second that?
Second.
Tiffany, would you like to do the roll?
Do you want me to do a roll, or we can just do a, oh, okay. Delegate Adams,
Yes.
Delegate Pippi,
No.
Delegate Crosby,
Aye.
Delegate Weigel,
Yes.
Delegate Valderrama,
Aye.
Delegate Waffle, Delegate Howard,
Yes.
Delegate Queen,
Yes.
Delegate Harrison. Delegate Harrison?
I'm actually not on this committee.
not
I'm
a
looking at
guest.
another bill.
Oh,
Okay.
sorry. Okay. Okay. 1, 2, 3.
Yeah.
Delegate Chi, would you like to vote?
I vote aye. Thank you.
Okay. 1, 2, 3, 4, 5,
Okay.
6, 7, 8 to
Favorable
1.
motion passes.
All right.
All right, thank you very much. Okay. And we'll be waiting for Delegate Pippi's amendment. Okay. All right, now we can move on to the to House Bill 301, which is real estate brokers, brokerage services related to real estate wholesaler.
So
wholesaling.
this bill requires real estate wholesalers to be licensed as real estate brokers by the Maryland Real Estate Commission. As a result, the statutory definition of provide real estate brokerage service is expanded to include engaging in buying or selling, offering to buy or sell, or marketing of real estate or otherwise dealing in contracts for real estate or options on real estate on 2 or more occasions in any 12-month period.
Okay, Delegate Adams.
The only thing I want to make sure on this bill is that we got a lot of calls from auctioneers who were very concerned that they thought this bill would apply to them. And does council have an opinion on whether this bill applies to auctioneers, or do you think we need to do something by way of amendment to make sure that that they're not captured in this piece of legislation?
So that question actually was asked at the bill hearing, and they stated auctioneers are not in this bill.
Okay. All right. So legislative intent being what it is, there's no need for an amendment. Their business model doesn't apply. Okay.
And I will add that we have not received any amendments from members on this bill.
Well, it would come from me if you felt it was necessary, but it doesn't appear it's necessary.
You know, they said at the hearing that they weren't included.
Anyone else has any questions? Council Erica, do you want to talk about the opinion of the Maryland Real Estate Commission on this?
Sure. So on the back of the fiscal note, there's an additional comment where the Maryland Real Estate Commission, they advise that they interpret the Real Estate Brokers Act to preclude licensees for engaging in wholesaling. for the most part. So if the wholesalers are brought under, based upon what they're saying, if wholesalers are brought under this license, they won't be able to wholesale.
So that sounds like it could potentially conflict with the intent of the bill, right? So even if you get these people licensed, according to the Real Estate Commission, they cannot conduct a business under that license. Is that my understanding?
That's my understanding based upon the additional comment.
Delegate Queen.
Well, I guess my question sort of is like yours. So how do we address that? Is it, do you get is it some way we can get another opinion to figure out who's right in this case?
I'm not sure. That's coming from the Real Estate Commission themselves. That's how they're interpreting their laws.
I also understand the sponsor, Delegate Rosenberg, intended to offer an amendment, but we have not received it. So if it's okay with members, I would like to hold this bill. Okay. To clarify with the Real Estate Commission about exactly what that means, because if you require a license and the commission says the license is no good for people to conduct that business, then what's the point of license, right? So.
Yeah, I would agree.
I mean, I understand what the problem we're trying to solve, which is in certain distressed communities, we have people who take advantage of the people who are struggling to pay their rent or whatever with their financial situations and offer to buy their home and then, upsell it, make a profit before the deal is even closed, right? So they sell the contract essentially instead of the real property, and it becomes an abuse. But I think we need to solve the problem. I'm not sure if technically this is the fix according to the Real Estate Commission. Delegate Weigel.
Thank you, Madam Chair. The Maryland Realtors also testified that they wanted an amendment. Did we have anything from them?
They contacted me yesterday, but we did not receive the official one from the bill sponsor, which I think missed the timeline or something. So let's give them a chance to offer an amendment.
Okay, thank you.
Yeah. All right. So I'm going to hold this HB 301. Okay. The next one is HB 832, which is labor and employment. Delegate Queen's bill, equal pay for equal work, wage range, transparency.
Yes, House Bill 832 expands the applicability, requirements, and penalties of the state's equal pay for equal work law to require employers to disclose the wage range for job positions. We also have not received any amendments on this bill as well.
Okay, so that was going to be my question, because there should be amendments submitted, and the amendments would clarify that this is a range that we're looking at, to make sure that was clear, and to say that it's only going to occur for the initial job opening, not for promotion and some of the other things that were listed, and nothing has come through?
I don't have anything here, and I've asked committee staff and they haven't received anything either. If you have it, you can email it to the committee.
Okay, I know I sent something to the amendment office. I'm just trying to figure out.
So amendment office doesn't send it to us. They send it to you and you would have to send it to us.
That's part of my question. Okay, so I have not gotten anything back. So that means the amendment office hasn't finished with it.
Okay.
I mean, that's how I should interpret that.
More than likely, you can always reach out and ask them.
Okay. So yes, let me make sure those amendments get in, if that's okay. But if there's other concerns that we need to address, I'd like to hear that so I can address them.
What about like recs? Like, how they have internal promotions for companies, they'll put out a rec.
Yeah, so no internal promotion stuff. That's all going to be cleared up. It's only going to be the first time offered.
Well, it might not be a promotion. It might be a lateral move so no internal employees. But I mean, a lot of times they have to make a rec available to the public for a certain amount of time. So that salary range would have to be on the government.
Yeah. Oh, when the government puts out the
or contractor. I mean, you got 40% of people in Maryland are subcontractors and contractors to agencies and groups in Maryland. So, it's going to affect a large body of people.
I mean, a large body of people, then we have to put the information out for? I'm not sure.
Yeah.
What part you're asking.
Yeah, but well, yes. We'll get together and clarify, but I guess what I'm trying to say is that, every time they're going to have to post a rec, they're going to have to post a salary range, because there's going to be people that are going to be, from the public sector that are going to qualify, or just from the general public that are going to qualify and be able to apply. So regardless of whether we limit it in the capacity of, well, if it's a promotion or thing, I guess if you're going from like manager 1 to manager 2, so like you're going from an M1 to an M2 position, that's one thing because that's internal. But if you're going from, a lot of times they'll have to make that position available, and you still have to interview for the job, even though you're working in that department, working in that area, and maybe even managing the team. That
I agree with you, Delegate Howard. If you put out a job promotion, I mean, that's how the government does now. If I put out a job description and says this job is in, GS 11, it has this salary range. That's what you do. Yeah.
Right. What about the private sector as well, though? So I'll tell you what, we'll talk about it. We'll look at, we've looked at this legislation before. Let's put our heads together and we'll talk about it. Pam, is that all right?
We can talk about it, but the idea is that, yes, if I'm putting out a job description, we want the private sector to mirror what you get in the federal sector, a range of the job, just like you do a description that says, I need to have this much education, or I don't need to have this, or this is a job that requires these skills. That range should be consistent. Yes, that's what we want.
We'll talk.
Okay.
But
Anyone else?
You're waiting for an amendment anyway, so yeah.
Yeah, we're waiting for her amendment, and at the same time, I want to see if any other members have questions. Okay, seeing none. I'm going to move on to the next one, which is HB 906. Okay, Erica.
House Bill, House Bill 906 makes several changes to existing statutory provisions that prohibit specified executive departments from denying an occupational license or certificate to an applicant only on the basis of the criminal history of the applicant. The bill also prohibits a department from requiring an applicant to disclose specified criminal history information and establishes a predetermination review process under which the individual can request the department to review the individual's criminal history to determine whether that criminal history would disqualify the person from obtaining the occupational license or the certificate. We've also not received any amendments on this bill.
And was there intended to be amendments?
Oh, I'm not sure. I'm just letting you know we don't have any.
Yeah. Okay. Delegate Adams.
So I'm very concerned about the bill. I mean, I'm an employer and recognize the importance of having people in public settings and also in homes and being able to review their history. Now, additionally, I'll just say there are certain laws. So, for example, on school construction, where students are present, employers are required to do a background check and to have that conducted before they show up on school grounds. That's only one of a series of examples. So unless I misunderstand what this bill is doing, I think we've had different versions of this bill in the past. And, my interest primarily is to have a workplace that I can determine whether or not people working are suitable in that situation. And I would not exclude someone with a criminal background, but the idea that I would not even have that information available to make a decision, I think yields some difficulties. Somebody working in bookkeeping, for example, handling my cash, wouldn't I want to know whether or not they have a background of fraud or embezzlement? It's so that there are a series of concerns I have. I understand why the bill's here, but that's my 2 cents on the bill.
Thank you. Delegate Pippi.
I mean, just similar sentiment. I mean, I feel like I understand what we're trying to do. There are some technical concerns, for example, and I know that I think our colleague, Delegate Harrison's here. Like the Board of Nursing, they had some concerns about dealing. Can you maybe address that? Have you seen that letter, Delegate Harrison, the letter from the Board of Nursing? And do you have any thoughts on that or a way around that?
Yes, Madam Chair, may I?
Please, yes, I was going to
Okay.
call on you anyway later, but yeah, please go ahead.
So just a couple of things, and then I'll come to your specific question, if you don't mind, Delegate Pippi. So the premise of the bill really is to create basically like a pre-clearance process. So if I am in Delegate, I forget whose example it was, if I had a criminal conviction of, stealing from a retail store, then yeah, you probably would not want to hire me to keep your books. And that's fine. So the individual would basically still have to go through all of the background checks and anything else that is necessary to get the job. This is just going to the licensing agency. So if I wanted to be a truck driver, and let's say I had a criminal conviction in the past of reckless driving, when I go to the license, I could go to the licensing agency that gives out truck driver licenses and ask, will this criminal conviction be a barrier to me getting a job as a truck driver? Well, they're probably going to say, yeah, probably it will. It's going to be a problem. So then I won't invest my money trying to go through CDL training to become a truck driver. I may go then and try to become a barber. And that's really what this is. This is really just about getting a predetermination of whether or not my criminal conviction would prevent me from, or would be a barrier to me getting a license in a particular occupation. So to your question, Delegate Pippi, regarding the nurses and the physicians, because it was basically all of the medical professions that had that same issue. They already do a level of checking. And so what they're saying is that we already do this. So why do we need to have this done on the front end? If we find something in your background, then we're not going to hire you, and we don't want to be bound to hiring you. So the individual, me as a person with the record, if I'm going to ask for this predetermination, then I have the responsibility of being honest about everything that may be in my background to ask, is this going to be a problem? If by chance you say, no, it won't be a problem, and then when we go through all of the processes to get this license, all the background checks or whatever it is, you find something, then you're not bound to that determination because I did not fully disclose everything. Does that make sense what I'm saying?
Yeah, I mean,
Go ahead. Yeah, please.
Yeah, I mean, I guess there's two parts. One, in that same letter of concern or opposition, what have you, they were just saying that they would get a lot of applicants that could potentially be otherwise likely unqualified, and it could cause some issues there.
Well, when I'm asking about it, if I, like I said, if I had a conviction where, I stole something from a pharmacy, some drugs from a pharmacy, then that's going to be an issue, and that will come up in the background check. And so therefore you would not want to have someone with that background, working with you, but I'm going to the licensing authority. So the Board of Nurses, and I will go to them first and say, is this going to be a problem? And if you think that if they determine, yeah, it's probably going to be a problem, then I won't waste my money going through nursing school and then only to get to the end and find out that it's a problem. So, really, like I said, it's a pre-certification process. And the nursing board then could give, individualized consideration, or whatever board it is, individualized consideration, of that applicant and the criminal background check, and, whether or not they have, gone through rehabilitation. Have they had any issues since they have either served their sentence or, had, a deferred adjudication, or perhaps they didn't get a conviction. They may have been arrested but didn't get a conviction. So it's a list of things that, or if it's been expunged, if my background, if my issue has been expunged, then that shouldn't be held against me. And that's the purpose of expungement.
Delegate Harrison, thank you for your response and explanation. Let me get to Delegate Crosby. Okay.
Thank you, Madam Chair. Maybe this is a question for staff. I know there is a fiscal note here. Have we heard back from appropriations, or are we still waiting on their response?
Yeah, that's a great question because it's a pretty significant fiscal note. So Council, please clarify for us what we need to do.
We're waiting on their response still. We haven't heard back.
Okay. Thank you. So because of the fiscal note, which is clearly over 100,000, beyond the merit of the bill, we have to hold it for technical reasons because we're waiting for the appropriations on this one as well. Okay. But I wanted to offer members a chance to weigh in on this and ask questions since we have the bill sponsor here. Okay. All right. Any other discussions? Okay. Otherwise, we'll just hold this bill. Okay. All right. And that actually concludes our work session today. Just stay tuned for other emails. We will likely have a couple more work sessions to finish our work this session, this legislative session. Okay. Thank you all very much for your important discussion, and see you on the floor. Thank you.